What if a multi-billion-dollar corporation could make its largest, most expensive legal problems simply disappear? This isn't a fantasy, it's a controversial legal strategy at the heart of a high-stakes debate unfolding in the halls of power. Companies facing massive lawsuits are using a complex maneuver to sidestep accountability, leaving victims with potentially nothing. The central question is this a legitimate use of our bankruptcy laws, or is it a cynical exploitation of a loophole that Congress must close? Let's look at the key exchange that reveals everything.
Ms. Naranjo, did I say your name right? I'm sorry for all
Yes,
your
you
trouble.
did. Thank you.
I'm sorry for all your troubles.
Thank you.
Mr. Zimbro, tell my old friend Phil Gelston I said hi.
Yes, sir, I will do so.
Very,
He had warm regards to send to you.
well, fine lawyer, fine lawyer. Professor Skeel, with respect to a divisional merger and then a bankruptcy, does the bankruptcy judge or does the bankruptcy court make a distinction between a divisional merger bankruptcy in good faith and one in bad faith?
Yes, I think a bankruptcy judge would. I think they would look at the bad co, to use the term that we've adopted from Judge Fitzgerald. They'd look at bad co and they'd ask the question, is that an entity that is in bankruptcy for a proper bankruptcy purpose? And if you set up a bad co that had real assets in it and it had the liabilities as well, you might say yes, that's a proper purpose for that for that entity. But the judge looks at what went on in the particular divisional merger and makes a decision.
Let me explore that a minute. I've not ever practiced in bankruptcy court. When a divisional merger is done, and then there's a bankruptcy, and you have two companies, I'll use the terms rich co and poor co, as opposed to good and bad. Does the bankruptcy, I assume that counsel for the creditors is raising fresh hell and saying this divisional merger was in bad faith and it was only done to avoid liabilities. Assume that's one of the allegations. Does the bankruptcy judge then hold a hearing and look to Porco and its present and prior management and say, tell me why you did this divisional merger? And if they say to avoid our liabilities, does the bankruptcy judge then have authority to say, no, get out of my courtroom?
The answer to that would be yes. I'll unpack it just a little bit if I can. So you do the divisional merger. There's nothing strange about a divisional merger in concept. I mean, you can have perfectly appropriate divisional mergers, and nobody thinks about it until we end up in bankruptcy. But if you do a divisional merger and then you put Badco or Porco into bankruptcy, and the creditors, the victims, challenge the bankruptcy, say it was filed in bad faith, then the bankruptcy judge assesses the divisional merger, the Texas two-step, and determines whether it belongs in bankruptcy or not. And the standards that courts use vary a little bit from court to court. But the standard that will apply in Johnson & Johnson, for instance, which is the Third Circuit standard, the Court of Appeals for the Third Circuit, what the court will ask is, was there a valid bankruptcy purpose? That was the first question. And then the second question is, was this bankruptcy filed simply to gain a tactical advantage in litigation? And if it's not a valid bankruptcy purpose or it was solely for a tactical advantage, the court will kick the case out. And there is a hearing in Johnson & Johnson in its divisional merger case next week to address that question.
Let me ask Mr. Zumbro. It seems to me that the issue is, do we have a prophylactic rule passed by Congress that says you can't do a divisional merger and then a bankruptcy? Or do we rely on the bankruptcy judge to decide when a divisional merger is in good faith and bad faith? Bad faith meaning to avoid your creditors.
Senator, I think that's right. I think the bankruptcy courts are in much better position to evaluate those issues than Congress. I don't think a law that flatly prohibits a bankruptcy filing after a divisional merger is appropriate or necessary. I did a divisional merger recently for a media company that needed to sell a content library. So if that company that bought the content library needs to seek bankruptcy protection in 10 years, why should it be precluded from doing so? I think the courts can make these determinations on a case-by-case basis.
I understand. Could I ask, Mr. Chairman, for 30 more seconds, could you weigh in on that, Mr. McClain?
Absolutely. First of all, what Mr. Scale said, what Professor Scale said, is not accurate in the Fourth Circuit. In the Fourth Circuit, where these bankruptcies are all originally filed, bad faith is not enough to dismiss the bankruptcy. A judge could find it's in complete bad faith, it's a scheme, it's a fraud, but yet if the defendant, if the debtor can argue there's a reasonable likelihood of a successful reorganization, a standard which is almost impossible to meet, then the bankruptcy has to stay. So dismissal is not an adequate remedy, even for bad faith under the law of the Fourth Circuit, where they, of course, file. Secondly, with respect to this prophylactic rule, think about the implications of what I've just said. The court's hands are bound. They're bound by this governing, controlling precedent, and it doesn't matter if it's bad faith. That's not enough. Judges are, of course, faced with the cases in front of them, and they do their best faced with the cases in front of them. But when there was such a widely used scheme where the wealthiest corporations go into bankruptcy to disadvantage some of their disfavored creditors, that is a universal problem that I would submit calls for a universal answer.
Okay. Thank you all. Mr. Chairman, I have been asked by Professor Anthony Casey of the University of Chicago Law School and Professor Parikh of the Lewis and Clark Law School to
Let's break down what's really happening here. The senator's line of questioning is a masterclass in simplification. He cuts through the legal jargon by creating a simple, powerful analogy: rich co and poor co. He's not just asking for a legal definition. He's trying to get the experts to admit the fundamental purpose of this maneuver. When he asks if a judge can throw out a case if the company admits it was done simply to avoid our liabilities, he is laying a trap to expose the core motive behind these bankruptcies. The responses reveal a deep and critical conflict in our legal system. First, you hear Professor Skeel and Mr. Zumbrow argue that the system works. They suggest that bankruptcy judges have the power to examine whether a divisional merger was done in good faith or bad faith, and can dismiss cases that are purely a tactical ploy. They're defending the status quo, arguing for judicial discretion on a case-by-case basis. But then, Mr. McClain completely dismantles that argument. He points out that in the Fourth Circuit, the very court where many of these controversial cases are filed, finding that a company acted in bad faith is not enough to dismiss the case. As long as the company can argue there's a reasonable likelihood of a successful reorganization, the bankruptcy can proceed, even if it was born from a fraudulent scheme. This is the crucial context. The entire strategy hinges on choosing a friendly court where the rules are different, a point that undermines the idea that judges can always be the gatekeepers of fairness. The key themes being exposed are the weaponization of bankruptcy, the inconsistent application of justice across different courts, and the debate over whether we need a universal rule to prevent this. This hearing is about more than just corporate structuring. It's about access to justice. The divisional merger strategy, often called the Texas two-step, is a way for a healthy, profitable corporation to isolate its liabilities. Think of it this way. A company is facing thousands of lawsuits, for instance, over a product that caused harm, like the Johnson & Johnson talc powder case mentioned in the hearing. Instead of facing those lawsuits, the company creates a new, smaller subsidiary. It dumps all the lawsuit liabilities into that new company, gives it limited assets, and then has that new entity declare bankruptcy. The original wealthy parent company continues to operate, shielded from the very people it allegedly harmed. The bankruptcy process then forces all the individual victims into a single, collective settlement, often for far less than they might have won in court. This isn't just a financial tool. It's a tactic that fundamentally alters the balance of power between ordinary citizens and massive corporations. So, what are the key takeaways from all of this? First, a legal loophole allows profitable companies to use divisional mergers to offload massive legal liabilities onto a new, underfunded shell company designed to go bankrupt. Second, the experts are deeply divided on whether the current court system can effectively police this strategy. Third, the legal standard for dismissing a bad faith bankruptcy is dangerously weak in some jurisdictions, particularly the Fourth Circuit, which corporations have strategically chosen for these filings. And finally, this entire debate boils down to a single question. Should we trust individual judges to make the right call? Or is this maneuver so inherently unfair that Congress needs to step in and ban it outright? This leaves us with a critical question about the nature of our legal system. Should the law serve as a rigid backstop against injustice, or should it be a flexible tool interpreted by judges? What do you think? Let us know in the comments below. And if you found this analysis helpful, be sure to like, subscribe, and share this video.